So I am Douglas Haig. I am the Vice Chairman of the Residential Landlords Association. I'm also the Chair of the Cardiff Landlord Forum, which is a local forum run for Cardiff-based landlords, although other landlords are welcome to attend. We run it every 2 months. We have speakers, obviously not quite as illustrious panel of speakers as we have today, but still very good ones. And we help educate and represent landlords locally. I'm also a private landlord, and I don't know about the private landlords of the room, but I sometimes feel like that is being a member of Alcoholics Anonymous. So the problem with having this slot is that after incredibly good speakers before me, I am now left with nothing to say of fact that I can tell you new, so I'm just going to give you my opinion, which I'm quite good at. So just, there we go, very briefly. The Residential Landlords Association, for those of you that aren't aware of us already, we represent nearly 20,000 landlords across England and Wales. We've got an association with the Scottish Association of Landlords across the border as well. And roughly that represents about 300,000 properties in the portfolio of the landlords that we represent. We're very much about improving the sector in providing training and general landlord services. We run a legal advice line for general help. For landlords, and we're very keen on accreditation and allowing landlords to set themselves above the other landlords in their sector by the accreditation schemes that we run and the training that we run. My role, predominantly within the RLA, is to lobby local and national governments on behalf of landlords. So I'm always very keen to hear the views of landlords on any aspect of their business, and I do my best to represent those views wherever and whenever I can. Sometimes I think that the civil servants probably don't like me very much, but that's fine. They seem to grin and bear their teeth very well. So very, very keen to hear from you. So the Housing Wales Act I'll start with, and then I'll go on to the Renting Homes Bill briefly afterwards. So I couldn't agree most with David much more, other than the fact that I was far more cynical at the beginning, and I opposed the bill right from the start, knowing that it wouldn't be very effective. Whilst the RLA's goal is to promote the private rented sector as the first choice and not second best, we very much believe in the private rented sector being a positive choice for tenants to live in, and that for landlords that need to provide a service to their tenants and quality properties, we don't believe that registration and licensing of landlords is the appropriate way of achieving this. Saying that, we are thoroughly supportive, as is David, of the concept of licensing agents, but I'll get on to that soon. Really, we struggle. And it's difficult, because when you're dealing with Welsh Government and you're dealing with local authorities, who, during the passage of my last 4 years of being on the stakeholder groups for this bill, and then consequently the Renting Homes Bill, you find that actually there is a huge difference between the local authority standpoints and Welsh Government standpoints. And it's really important when you're dealing with local authorities to remember that. It's a bit of a tip for you. And that whilst they have to grin and bear it a lot of the time, they're very often under the same sort of cosh and behind closed doors, and not quite as keen on some of this legislation as the Welsh Government might want you to believe. We believe that registration and licensing will only collect you guys in this room. We've got up there the rogue landlords. I've deliberately put that word up there because I hate it, because it makes this vision of a cheeky chappy, of someone that's, no, he's just got it wrong, that's all right. But it's not that at all. It's not that at all, because there are a whole bunch of landlords in this sector, a very small minority of them, but there's still a significant number that are criminal landlords. They know full well what they're doing, and they are going against what they should be doing. And that's how I want them to be called. The good landlords, which are the ones in this room, members of our organisation, members of other very respected landlord bodies, who I won't name, of course, and are complying and doing the right thing. And the rest of us, well, housing law is very complicated. I'm glad to see David reference the RLA's point of there's 100 pieces of legislation with over 400 regulations underneath it. It's a complex area, and it takes a lot to learn it. And that's why we are so positive about training, but this mechanism is not the one to do it, because ultimately the incredibly overstretched environmental health officers will ultimately be focusing on achieving the targets that will be set for them to register as many landlords as possible, and not actually going after the guys that they need to, and those landlords will be you guys here. So ultimately we think that despite the fact that the Welsh Government keeps telling us that they want us to grow the sector, and that was confirmed in the evidence session yesterday, they want us to grow the sector, they want us to house more of the homelessness within Wales, and they need us to do that because there's not the money to build the social housing, and planning permission is not being granted on anywhere the rate that we need it to be for the only occupation sector to grow significantly either. So they do need us to continue to build and supply housing. But on the same side, you get legislation like this, which seems to counteract that intention and just make it more difficult. So I don't like just to complain, although, yeah, we've got to admit as landlords we are pretty good at complaining. But we do like to try and put forward alternatives. So we like to register, we want tenants to be able to register where the rented properties are. Because quite frankly, I don't care if my tenants tell the local authority that I'm a landlord and that they're renting a property from me. And I don't think anybody that's doing it appropriately is going to care either. We want to see a system of co-regulation, which is very similar to that with the building that's existing in building regulations, where those that are members of professional bodies can lift themselves out of the enforcement regime. We will deal with you on the basis of if you're one of our members, if there's a complaint, and then those that aren't members of those schemes will be targeted by the local enforcement officers, and that frees up a lot of their enforcement time. And we came up with a number of other methods as well. But nevertheless, it will be going ahead, and we will be fighting on your behalf to try and make it as unbureaucratic as possible. Now, I'm going to do something that Anne Rowlands absolutely hates me doing, so I'm going to tell you what the fees were originally proposed at the very beginning. I will clarify before I even put them on the screen that these are not the fees that they will necessarily be, but to hold people to account, because this is what was put in the financial implementation information presented to the Assembly when it was approved. I think it's appropriate that they go on the screen. So the basics are around that. So let's see whether they do genuinely fit around that. But a note on this is that we're looking at autumn, maybe October, for this scheme to be implemented. We're at a point where we're considerably into a financial year. We run businesses. We are professional people. We have to budget. It was a very good point that was made to me earlier today. We are so far away, as Anne previously said, from knowing fully what the details of this bill are, and yet there's only 5 months before it's supposed to come in. I don't think that's appropriate, and I don't think that's good practice, and I don't think that helps the industry prepare for what it's supposed to be doing in the responsible manner that it should be doing it. I'll skip these bits. There's going to be a lot of slides that skip because everybody else has covered them. But so in terms of the prescribed information, there is a consultation out which is just closed, which you can get the information that they're proposing to prescribe if you want to look through that. I do really encourage you to take advantage of the consultation processes that do exist. There will be a number of them coming up. There's still the Code of Conduct one to submit. Take the time to read it. Take the time to respond. You don't have to write volumes every time, but your opinions are very. I do think they are read, and sometimes they are acted upon, and it's easier if lots of people reply than just one person. And quite frankly, we want to hear what your responses are as well. So if you want to send them in, then send them along to us as well so we can read through them. Concerns around the registration details. Obviously, for landlords, it's not nowhere near as much information to keep inputting as it is for agents, but we're concerned around the process of constantly criminalising landlords that are not really carrying out criminal activities. So by not putting the correct information in or updating it on a regular basis, it's not a lot of the time it's not something that you're deliberately doing. It's just something that doesn't necessarily come to the forefront of your mind if you've changed your mobile telephone number. I must update the landlord register as well. You're thinking about all your mates and things like that and your family. Or I tend not to tell my mother when I've changed my mobile number. It's a concern. And I'm sure that local enforcement will take this reasonably, but they have the powers to not take it reasonably. So we've asked that they limit the information that they've asked for, because it is quite, in our opinion, it is quite a lot. So again, in terms of fees, that's the figure again, in case you want to see them for future. Just we will be reminding them. So our argument is that the fees should be set, as I think David mentioned earlier, that the fees should be set in accordance with a panel, and there should be representatives of agents and of landlords on that panel, and that the whole scheme should be held to account by that panel. Because how many licensing schemes have you seen come into effect in additional and selective licensing schemes that have had no real scrutiny or measure as to whether they have been effective or not? And I don't think that's acceptable, and I think if you're talking about a national scheme, then there should be transparency and that panel should be created. And we've also argued, and I believe it's semi-been confirmed, but not fully confirmed, that Landlord Accreditation Wales members will be given some level of discount and bypass some of the necessary training requirements. And that's a very positive thing, so I hope that does come to fruition. So continue to get accredited. We thoroughly support accreditation. The training obligations have yet to be finalised, expected to cover the core subjects, but we've also argued that actually there should be a real diversity in how landlords can accept that training, because landlords will be all over the country. Just because you've got a property in Wales doesn't necessarily mean that you will indeed be living in Wales, so therefore things like online courses and online training we think is absolutely vital. We've got a number of members that are landlords that are disabled but are very keen to take advantage of training, and they find the mobility problems, especially in rural areas. So we're keen to make sure that the training providers are allowed to provide diverse training formats. And again, that the Landlord Accreditation Wales members are fast-tracked. So what can you do now? Well, so there's 2 slides around this. So you need to think about whether you want to manage your property or not. Welsh Government don't think that this is going to impact on landlords in any significant way. They don't think it's particularly burdensome, and they don't think that there will be necessarily many changes that are required for landlords to make. I disagree. I don't know whether you got that. I think that this will drive a lot of landlords out of managing their own properties. And I think that combined with the changes in the Renting Homes Wales Bill, it's going to drive more landlords out of managing their own properties, whether that bill intends to do it or not. And I'll get onto that bill in a minute. You need to make sure you have the necessary finances in place to be able to afford the licensing and training. That may be simple for maybe one property landlords, but we have estates, we have large landlords. The way that the registration fees have been set up means that me personally, the way I've set my portfolio up, I'm going to probably have to pay multiple registration fees because because of the way that the legislation is put forwards, and that's a concern. That again makes me think that they don't fully understand the sector. So the other thing to do, check the RLA website regularly. We keep an update on things. We tend to have a different perspective on stuff. So please do that. Agents, I thought I'd touch on agents, because ultimately agents service us as landlords, and I'm very keen on the professionalisation of that sector, and I'm very keen on the licensing of that sector, because ultimately, there we go, agents provide a service managing our most important asset. Often it's our pension or our income, and it takes us a long time to get there. It's pretty important to us. Not all of us were just born with 50 properties in our back pocket. We worked very, very hard to get there. So in our opinion, agents should be held highly accountable. I think that Welsh Government misunderstands the agent market significantly. And I think that the fact that they pretty much see them on a par with landlords is not appropriate at all. I think that the licensing should be a lot more rigid with agents, and the training should be a lot stricter requirements with agents as well. I agree with David's point on who should be trained and licensed before they can practice. I don't think that necessarily that backroom staff and things like that should all require before they do anything. But the point is that as landlords, you are responsible if you appoint an unlicensed agent. So you've got to, and that fine is one of the biggest fines that you can face in this bill if you appoint an unlicensed agent. So you really have to make sure that that agent is doing things properly. And the problem with that is that if you are an unlicensed landlord, you won't be able to do very much with your property. So it's going to be very difficult for you to hold that agent to account because you won't be able to do condition inspections or check up with the tenants. So you could, because if you put yourself in that position, that puts you in danger of carrying out licensed activity without a license. So my recommendation is, even if you are an investor, someone that just purely is buying a property and handing it over to the agent, that probably you should get licensed as well. I think that there's going to be very few cases where you're going to have landlords that can really get away with not licensing as well as registering. So, saying all these things, it may seem that actually we are not keen on raising the standard of the sector in terms of landlords, but that's not true. We've just been through a general election of which the private rented sector played a significant part in some of the policies of those parties. So we as a sector, as landlords, have to turn around and look at ourselves, and we have to decide where we want to be by the next election, because I can guarantee that unless we raise our game, we will be in a position where we will be forced with rent controls. We will have all agents' fees banned. We will have long-term tenancies imposed upon us. And whatever else comes about. They're talking about some of Generation's rents proposals are to remove mortgage relief, interest relief on your tax returns. You know, these are significant bodies lobbying for significant changes to this sector. And we have put ourselves in this position because part of our sector is not doing the job properly. So we have to raise our game. And we have to do that through looking at ourselves and deciding where we want to be. So the RLA believes in a better private rented sector and believes in trying to take as many landlords on that journey with us as possible. And that's something for us all to think about in the coming years. So anyway, slightly more positive, hopefully. The Renting Homes Wales bill. Well, we're a lot more positive about this. Of course, I've got some misgivings around it. I wouldn't be here if I didn't. But the overall concept of that, as Professor Parkinson said earlier, was to standardise the contracts. So to enable a secure contract and something that is very similar to the current AST. I won't go into too much detail because I'm sure it will be talked about a lot later. But I do want to talk about some of the main key points and some of our points of view on the sector. So the first one is the end of the 6-month moratorium. Now, some landlords, or many landlords, won't even know that that exists. That actually, if you grant a 1-month tenancy, you can't actually get possession of that property if you needed to until 6 months. The judge won't give a possession order until 6 months. A lot of the times that doesn't matter. When you grant short-term tenancy, that tenant leaves anyway. But realistically, you could be putting yourself in a bit of difficulty if that tenant decides to stay, especially if you've rented out afterwards. Our proposal, really, we support this proposal because we think it just reinforces the flexible tenure that the private rented sector provides. And it's as simple as that. They say that, the opposition groups say that it's going to make the security and that we're all going to grant 1-month tenancies. Well, quite frankly, that's ridiculous. Who wants, as landlords, to grant 1-month tenancies constantly and kick our tenants out? There's always this great myth that landlords just love to kick tenants out. Well, no, it's very expensive to do that, and I can show you the bills on my desk that prove it. So we want long-term tenants. So one of the main proposals that was put forward, that we have now put forward as well, to counterbalance this insecurity is a long-term tenancy proposal of a right to renew for tenants that want to stay for between 3 and 5 years. Now, there is no standard contract for that, and many landlords are very nervous about doing that, so we've submitted that proposal to Welsh Government. We are making it shortly available to the public to get their feedback on it, and we're hoping that they will, that landlords and agents will give us their opinions on that and see if the Assembly like to take note. Retaliatory eviction, David's covered that very well. There are so few retaliatory evictions, it has been blown completely out of proportion. It does exist. We can't deny it does exist, and we'd be stupid to try and pretend that it doesn't. But really, does it exist to the level that it's being played up to? No, I don't think so. Our main point with the retaliatory eviction clause, whilst we're not saying eradicate it entirely, is we want to see two main things. We want to make sure that any retaliatory eviction claims do not delay possession proceedings whatsoever. They're long enough as it is, and it's incredibly concerning that this power would be given, because the way it's drafted is very, very wide. And we would like to see an official repairs reporting procedure put in place, not dissimilar to maybe parts of the Deregulation Act, but hopefully simpler to manage. I think that's just good practice. And if you're encouraging tenants as part of a tenant education programme, which is what we should all be doing, because better educated tenants mean better tenants overall, most of the issues within the private rented sector are caused because either side doesn't understand the rights or obligations of themselves or the other party. So that's the proposals we put forward for under retaliatory eviction. Have I gone too far? Yeah. Fitness for human habitation. This was a fairly late addition during the stakeholder meetings in terms of looking at raising standards, condition standards within the PRS. Now, I don't think we can deny that there certainly for many properties the standards need to be raised. However, there are very complex tools that are available to be able to reach a very decent standard within private rented sector. And instead of introducing an entirely new fitness standard that will just complicate things even further, what we would like to see is a revival of something like the LACORS or LACORS, however you like to pronounce it, system that governed fire regulations around HHSRS. We'd like to see that extended to the 29 hazards, because whilst it allowed you to, it didn't give prescriptive standards, it gave you very clear ideas on how to interpret the HHSRS regs. So, and I think that would be much clearer for everybody and achieve what we want to do. In terms of abandonment, I think that's a very positive thing. Some areas, some agents, some landlords may never have experienced it, but certainly in South Wales, if you've got any experience in the Rhondda Valley or areas like that, then abandonment is quite common, unfortunately, and it's quite difficult to deal with. And advising landlords in these circumstances is often very frustrating when you say, well, theoretically, if you want to completely cover yourself, you have to get a possession order. Well, but we know they've definitely gone. Well, that's up to you then. So this takes steps to allow that procedure to happen in a legal way. We're quite positive about it, that we think the timescales are appropriate. Others are arguing that the timescales should be made longer. If we make them much longer, then we may as well get possession proceedings. It is an evolving bill, so there are still lots of opportunities for you to feed back in. The plenary sessions are very interesting for people like David and I, very boring for you lot, but if you want to watch them, they are available on seneth.tv, and the transcripts are also very boring as well, but they're available shortly after each one. So it tells you the mood of the Assembly members as to where the bill is going to be. We've obviously been submitting evidence, which is freely available. And I thought I'd just give you a list, which is actually in the guides. I'm being waved at. It's actually in the guides to give you an idea of all the areas of this isn't a comprehensive list, it's just what I could think of at the time, but all the differences that Wales has either currently or coming up over the next few years between the UK, between England and Wales. And it makes Wales a fundamentally legislatively different environment to do business in. So you really need to pay attention, you need to look up each of those areas, and you need to understand what they mean for you. So keep up to date, support us, join us if you want to. We genuinely do a lot of activity to try and support landlords. And if you want to hurl abuse at me on Twitter later, that's my details.